All right. Hello, everybody. Thanks for joining on a Friday. We'll probably have some other folks trickling in. I'm Kevin Frazier. I'm an adjunct professor at Delaware Law and an emerging technology scholar at St. Thomas University College of Law. Got my great colleagues, Christy and Rebecca, and we're just really excited about Lunch GPT getting started again. I'll bet this isn't exactly lunch, at least not on the East Coast. But I don't think we should call it happy hour GPT because that's too long of a name. And AI and law is a serious topic, so we can't have too much fun here. So the kind of run of the show is each of us, Christy, Rebecca, and Michael, are going to run through some of the AI and law news that's been top of mind for us. We're a small group. Right now, we have a small audience. If at any point you want to raise your hand, interject, leave a comment, tell us to talk about something else, do it. We want to hear from you. This is for you all, anyways. And so, really excited that you decided to come hang out with us and talk about AI and law. All right. Well, with that intro out of the way, I'll go ahead and get us started. So the thing that was taking up most of my mental space, well, hopefully not most of my mental space, but a lot of my mental space with respect to AI and the law this week was Doge and its use of AI with respect to the Department of Education. So to the extent that folks don't subscribe to the Washington Post, or are actively studying and maybe not keeping track of Doge as regularly as some of us, the short story is, as reported by the Washington Post, that Doge staffers descended upon the Department of Education and very quickly went about using Department of Education records and disclosing those records to a third-party AI system for the purpose of identifying potentially fraudulent or wasteful activity. And from some perspectives, that may seem like a good objective, right? All else equal, I think most of us would raise our hand and say, do you want a government that's more efficient or not? And usually you would say, yes, I'd like a more efficient government. And do you want to avoid things like fraudulent spending? Again, yes. Can AI help with that? Yes, right? AI can be very helpful in identifying waste, identifying patterns that otherwise would elude humans. So let's just put that to the side and specify that there are a lot of positive use cases of AI. If you really want to dive into how the federal government has used AI, I'd encourage you after this, just Google AI use inventory. There's an inventory across 37 agencies documenting 1,700 different uses of AI. And you'll see that many of those are uses you'd applaud. So, for example, the Army Corps of Engineers uses AI to help predict where flooding is going to occur. Good stuff, right? Especially if you're in a flood zone. The Department of Defense is using AI to improve its cybersecurity capabilities. Again, good stuff. So the issue with this particular use of AI by Doge is the Privacy Act. So if you haven't taken privacy law or you just haven't read the Privacy Act in a minute, the Privacy Act of 1974 was written in response to Watergate, and just general concerns about protecting information and kind of the general mentality that the government may not always be as trustworthy as folks were hoping. So the relevant provision here, and I'll read it like any good law professor. Here, the act prohibits an agency from, quote, disclosing any record which is contained in a system of records by any means of communication to any person or to another agency. So the key words there, number one, disclosure, right? What constitutes disclosing a record? So courts have interpreted disclosure very broadly. So disclosure may be even posting that information to a website. Disclosure could be something like disclosing that information to a third party. So let's hang on to that for a second. What qualifies as a record? Again, record is something that has been broadly defined. In this case, we're concerned about personally identifiable information being included in some of these Department of Education databases. PII, slam dunk. That's a record, right? So we've got disclosing a record to any person or to another agency. Here, disclosure to a third-party AI system would almost assuredly qualify as a disclosure in that context. And so the issue is if we see that we have a disclosure of a record, then we have to ask, okay, are there any exceptions? Because the Privacy Act includes at least 12 exceptions. For example, consent. Has the data subject consented to the use or the disclosure in question? Well, in this instance, Doge, to my knowledge, did not send a message on X asking every user, do you consent to us using your information to identify waste? Didn't see that, right? Other exceptions are things like national security interests. Could you maybe make a convoluted argument that somehow sorting through Department of Education records would save money that could be allocated to defense, which would further national security? Maybe if I were betting, a federal judge isn't going to say that's a permissible exception in this case. And so the long story short is, as meritorious as the idea of identifying waste may be, the fact of the matter is the current approach to using AI by Doge in these agency contexts seems to run directly into the Privacy Act. Now, part of the issue is the Privacy Act doesn't necessarily afford those users, those individuals whose data is implicated, many remedies against this use. So one of the issues is, per the Privacy Act, usually you have the ability to pursue a civil action if you request to access certain information uh, that is being held by an agency and it's denied. Well, in this instance, we haven't seen users requesting to access their information in Doge or the Department of Education saying no. Um, the other thing that we may see is Doge officials could be civilly liable if they access the information by telling the Department of Education officials under false pretenses what they were using that information for. Again, I haven't seen any information between Department of Education officials and Doge members about what that relationship looked like, but that's something we should pay attention to. Of course, I wouldn't expect the DOJ to actively try to pay attention to the Privacy Act with respect to Doge's use of it, given that that would be shooting the administration in its foot, and that hasn't been the case so far. So, a story to watch because, in particular, reporting has suggested that Doge is going to continue to kind of emulate its tactics with respect to using AI, going through agency records and trying to identify waste. So pay attention there. Maybe we'll be reporting on this during our next session on the 24th, but wanted to give you all that inside scoop, or really outside scoop. Anyone have any questions or comments about that? That's fine. The good news is that's the end of my content, so don't worry about that. Rebecca, I'd love to hear from you next. Please introduce yourself and tell us what's on your mind.
Yeah, hi everyone. My name is Rebecca Forden. I am a law librarian at Ohio State University's Moritz College of Law. And I wanted to talk today about hallucinations, which I'm sure we hear plenty about. Probably one of the first times that like AI really broke through to the mainstream for lawyers, I think, was when there was this case in New York, Maravilla Bianca. A couple of lawyers ended up in the New York Times because they had used ChatGPT for legal research. And since then, we see it all over the place. Uh, so I have a librarian friend who's tracking these, and there's hundreds of them that she's found. So it just keeps happening. So the latest case is one called Wadsworth v. Walmart, and I'm going to put the docket in the chat here. And so this one's kind of unusual because up until now, the cases that we've seen have mostly been like smaller firms or like a solo or people that maybe don't have access to the even basic legal research tools like the Mata Viavianca attorneys. They were a small firm. They had fast case, but they didn't have access to federal cases. And so they're like, they end up with a bankruptcy issue and they're like, what do we do? And so they turn to ChatGPT. But this is a firm, the firm is Morgan and Morgan. It's like, they say it's the 42nd largest firm in the nation. It's a plaintiff's attorney firm. Uh, and so what happened is that the brief that they submitted had, something like 10 hallucinated cases that did not exist. And so the court issued an order to show cause and asked for a detailed explanation of how this happened. And so what they said was that one of the attorneys used their internal firm AI system, and they didn't really say more about that. If you want to like look at the docket, there's two declarations that were just recently filed that you can read to find out what all they say. But it was kind of funny. Like the name partner is talking about all these lofty, like from the time of learned hand, it has been important to tell the truth, et cetera, et cetera. And then the more junior attorney, who's still pretty experienced, he has like 15 years experience, so he's not like a brand new attorney, but he was like, "This is all on me. If anyone is going to be sanctioned, let it be me." And still, neither of them explained how exactly, like, what system were you using and how did this happen? Like, did you have training at your firm? Did anyone know what this was supposed to be used for? And apparently they now have added a pop-up that says to their internal platform that says, check sources or whatever. So great. But I think part of the reason that it keeps happening is because people have this misconception um, that LLMs or generative AI in general is an information retrieval tool when it is not. It is a text generation tool. And sometimes the text that is fed to it as to make new text can be legal text. So that's what Lexis is doing. That's what Westlaw is doing. That's what like newer companies like MidPage are doing. But ultimately, it is creating text that's not going and finding it. They may be combining the LLM with other systems that are going and finding that text, but the LLM itself cannot do that. So it cannot go find a case. That's not within its capabilities. And most of them have not even been trained on all case law. So it's not even in what they've been trained on. Uh, so, so yeah, I thought that was a good way to just kind of like re-up some of those issues with you all. And then the other thing I saw, which kind of related, is I'll put this in the chat too. The BBC did this study where they fed their own research articles to some AI assistants, and they looked at errors in the responses that they got. They asked it questions then about like news, and then got some responses and reviewed the AI answers for accuracy. And they found 51% of those AI answers about the news had some significant issues. So 51%. I thought that was really disturbing and kind of put a number to some of the anecdotal things that I've been hearing from people who in like their Google answers. I'm sure we've all, done a Google search and you see the AI that comes up that tries to answer your question. And like sometimes it's good, sometimes it is not. But I wonder if it really could be as high as 51%, that, if the errors in things like Google we see every day are similar to what BBC found. Yeah, so that's kind of what I wanted to cover. I guess the other thing I'll say about the hallucinations thing is that, so this is the first, like I said, that we've seen at like a major big law firm, but I think that the firm still has some incentives that are a little bit different from other firms. Like it is not an AmLaw 100 firm. It is not like a big corporate law firm. They're a plaintiff's attorney firm. And so their incentives are to get through like as many cases as they can so that they hit a contingency fee on one of them. So they don't necessarily have the same incentives of law firms, which are like really concerned about reputation and would never want to see, they might lose a bunch of their clients if a hallucination like this came up in one of their cases. I don't think Morgan and Morgan is really going to be losing many clients, but because the clients aren't coming to them based on, you know, articles in the ABA journal or whatever, their clients aren't reading ABA journal. So I think that it kind of highlights the difference in tools, though, that I don't know. I guess just the different incentives that different firms may have, and that attorneys who don't necessarily have an incentive to do perfect research, this may just keep on happening because it otherwise meets their needs, and so
But
we
they
may
have
just
pop-ups now. It just
right.
pop-ups
They've
for
solved
everyone.
it.
It's no big deal. Just a little clippy in the corner, problem solved.
Yes.
But thank you very much, Rebecca. That's fascinating and scary, of course, especially that incentives component. I sniff a law review article coming on of doing an empirical analysis of hallucination sanctions and the size of the firm and the type of firm. I don't know. Or a note for anyone listening. Christy, did you want to jump
Yeah,
in?
and just to jump in about, I think that is such an interesting thought about incentives. And but I still, when and I was just presenting to students this week and had a couple on a slide headlines of recent hallucination cases to highlight to law students, hey, this is still happening and lawyers are still submitting it. But it really does baffle me when you think about putting a hallucinated case into a brief. You should be reading every case that goes into a written piece of work to the court, and I guess there's those incentives that doesn't always happen, those sorts of hallucinations, as opposed to after the Stanford study came out with the hallucination rates for Lexis and Westlaw, right, with a wider definition of what's a hallucination. Is it and when it cites to a case but it really gets it a little wrong, or maybe something even a little worse, it cites to a case but it's to the dissent. But just just the surprise that and duties of attorneys that they're submitting briefs with completely, when it would take a really minimal amount of time to check if that case exists. So
Yes,
Well,
yeah, and I think firms have, and I would think Morgan and Morgan would too, but like I know firms I've worked at have like this process you have to go through, like every brief gets site checked. So I don't know if they don't have that process or if that just did not happen or what.
oh boy. Geez. Well, a gift for judges looking to punish lazy lawyers. But Christy, with that, why don't we go to you for your 2 cents this week?
Sure. Well, I'm excited to be here, and I'm Christy Chamorro. I'm the instructional and educational tech lawyer at UC Berkeley Law School, and love learning alongside all of you about, as we're riding this wave of Gen AI development. So, one thing I've been thinking about over the last couple of weeks, and really just the, maybe last 6 months or so, is as we're hearing more about AI agents, right? And when Claude, I don't know how many the law students here saw when, I think it was in October, Claude released a video showing a demo of their AI agent that took over a browser screen, and that created some buzz. So for those of you who haven't been looking at this, to back up a little bit, what is an AI agent, and why should we be thinking about them? So these are these AI tools that can be given a goal and pursue the goal autonomously. So they go beyond what LLMs are doing and generating text or images. They're actually doing something. So they're performing dynamic steps, maybe multi-step reasoning, with or without human review, but folks have been thinking about this more broadly, and there have been releases in other areas, like Salesforce has their big AI agent that was released, I think Agent Force in September, that does and creates custom agents for customer service. So again, creating these tools that are using LLMs, but are doing things autonomously. But the reason why this was on my radar screen the last, I guess, 3 weeks is the two big releases from OpenAI starting late January of Operator, and I'll put the links in the chat after I'm done, but Operator and Deep Research. So I'll be curious what others here, if they've done any playing with either of these, but these are two tools that involve AI agents from OpenAI. So Operator is, maybe I will go ahead and just put this in the text now, is, well, wait just one moment, can't multitask. OpenAI's Operator is their agent. It's available only to their highest level. Pro is $20 a month. Their higher level, I'm blanking on, I think it's also called Pro now, but it's $200 a month. And I will admit, my husband is going to be really irritated, but I couldn't resist. And I said, for 1 month, no coffee. I'm going to just spend the money and test this out because I just couldn't wait. So what Operator will do is it gives you some predefined things you can give a try to, like, I want to cook dinner tonight. Please fill my Instacart, place an order for me, book a table for me on OpenAI, opens in a separate browser, like an internal browser. And some of these things I'm pointing out because I think, well, there are a lot of important legal issues that are raised by these AI agents, and we'll do these tasks for you. Sounds like so far there's been some interesting test cases with these. One of my favorites was, I'm a big fan of the Hard Fork podcast, New York Times, with Kevin Roose and Casey Newton, and they did some tests and said it probably, maybe someday, but right now I think when Kevin Roose tried to place an order, it was thinking he was in another state, and you can take over, but it was a little underwhelming. But then OpenAI also released their deep research tool, not to be confused with Google's deep research tool, but this is a tool that uses multi-step reasoning and AI agents, in the sense that you give it a prompt, you ask it to do deep research, and it will go off and do that research, and in 5 to 10 minutes give you a report with sources. So there's been a lot of benchmarking on that. It sounds like, folks like Ethan Mollick from One Useful Thing, one of my favorite people in this space, has been pretty impressed with it. Some hallucinations definitely still there. It's only getting sources from the web, not behind paywall. But, it really is, I think, ushering in possibly a new era of how we're going to be engaging with these tools. And in the legal space, there have been some folks who have, there's definitely AI agent tools out there. I think we have to, we all, and law students, need to be aware of AI washing. Like, what does that really mean when they have an AI agent, and be critical consumers, which is one of the reasons why I think it's just really important to understand how these work and what they mean, and to think about some of the potential legal issues, who's liable when an autonomous AI agent makes a decision, data privacy and compliance, ethics when, you're going to have this AI agent go off and do something for you in legal practice. Right now it looks like, from what I'm reading, it's there's some interesting uses for kind of low level tasks that take time. You can get that out of the way, like a lot of AI, where we're thinking, okay, these lower level tasks to free up time for more of our high level and creative thinking. But I think these two releases, which I will put in the chat, from OpenAI, really have raised some interesting issues about how we will all be using AI agents at this time next year, perhaps.
I've heard from a couple folks that 2025 is the year of the agent.
Yes, yeah, that's a
So
lot. Yep, yeah.
yeah, we'll see how that bears out. And Christy, kudos to you for sacrificing for research. I would
Yeah.
spend that coffee money and go to Cafe Strada So kudos to you. For those who don't know, the best mocha in Berkeley, in my opinion, is right across the street from Berkeley Law, and I was slightly addicted when I went there. I'm not proud to admit it, but
Yep.
awesome. Any other questions on AI agents? Has anyone else experimented with it?
Hi, I have a quick question for Christy and the rest of you, I suppose. Uh, so for quick background, my name is Anu. I'm a 2L at Cornell, also from the Bay Area. Worked at an AI company last summer, so very interested in the space. It seems like over the last few months, there's been a broad diversity in applications for different AI agents. I mainly use Perplexity, and they have a shopping agent now, where if you buy something through them, they will pay for shipping if it's not free, which is very convenient because I'm usually buying things from like internationally, and I don't like $30 shipping fees in whatever currency. Uh, but there's a lot, as you mentioned, more research oriented and task focused ones. I'm curious if you think like what the order of law and or regulation might look like between like shopping agents and research agents and like the order of operations there. Because like that's just interesting to me as a law student.
Yeah, I mean, I have just started to look at this kind of agent, this from the legal perspective of what kind of, contractual obligations will traditional agency law apply. I think it's also interesting to think about with different tools. And I have not tried Perplexities. I'm really curious. I think there's an interesting bit with these agents and at what level, right now, as I've played with them, you're sort of there and able to take over, like to make that final step, to make the payment. Or so to me, I think it's going to depend on the specific tools, how much really is autonomous, how much are you involved. But I think it's going to raise a lot of interesting legal issues. That's a great question, and it would be interesting to report back more on that in one of our future sessions. But I don't know if others have thoughts about some of the regulatory and other legal issues. Great
Yeah, I
question.
think the and thanks Anu for joining us. Awesome to hear that you're interested in this space. I think if you look at just how things have been treated so far, there's that kind of case study of I think it was Air Canada chatbot responded and said that it was going to waive some fees for a passenger for a bereavement flight. And then Air Canada said, no, that actually wasn't our policy. And they said, push it, it's your AI agent or your chatbot in that instance. It
Mhm.
said it was covered. That's the end of the ballgame.
Yeah.
I wouldn't be surprised if some of these AI agents, because like one hypothetical I've posed to my class is imagine you want to book a hotel reservation and you think you're booking a cheap option, but the agent ends up booking the most expensive suite or something on your behalf. Are you on the hook now, right? For that $750 a night hotel when you thought you were going to get a 150? That's a really so I wouldn't be surprised if there's some settings that companies end up adopting saying here's a specific budget you may be able to have, for example. Um, if you're looking for a really challenging note to write,
Yeah.
think about CAPTCHAs, right? How are we going to, when you're thinking about authenticating that this person is consenting to go through this next step or giving their authorization to go to this next step, what does it mean? Because now it gets tricky, right? So you had the company release this agent. Now you're deploying that agent. When can it sign legally on your behalf? For instance, if you ever need that final signature, when
Hmm.
does that come into play? Especially if it says, you're a human doing this.
Yeah.
What does that look like? So all these terms of services are going to have to go through radical changes to accommodate for AI agents.
Yeah.
Fun stuff. Thanks again. Michael, what's top of mind for you, good sir? And are you adequately sheltered given the frigid temps up in New York?
As a Midwesterner, they're not too frigid. Yeah, they're normal winter temperatures back in
There you
Iowa,
go. Bring it on.
but I'm probably not as bad as in Ithaca. So we'll take it in New York City. Um, yeah, so it's been a rather busy week and a half in the copyright world, which is mostly what I do. here at NYU. So probably the biggest update is the first case on whether fair use, this main exception to copyright infringement, applies to AI or not. There are a few caveats, so the sky is probably not falling, but the decision in brief involves everyone's potentially favorite legal research service, Westlaw, or least favorite. I think more of my students fall on the pro Westlaw side than the pro Lexis side, but opinions could differ. Um, and this newer company called Ross Intelligence, and Ross created a competitor product that was supposed to be using AI to similarly trawl a whole system of information and pull similar cases based on users' queries. And they trained the data set was all based on these memos that were written by lawyers who were hired but used Westlaw's headnotes and the information contained within. And a lot of the information that's being put out through this Ross system seems to be very similar to the Westlaw system, at least in some instances. So this is a case that's been kind of kicking around in the District of Delaware, but is actually before Judge Bibas, who usually sits in the Third Circuit, but by designation has been down dealing with this case for a few years now, and this is now the second summary judgment order on it. And the judge held that fair use should not apply in this situation. So in copyright law, we have 4 factors that fair use is supposed to consider. Theoretically, they're non-holistic and not exclusive, so we should consider other things. In reality, we only consider those 4, and there are really 2 that are the most important. One being what the purpose of the use is. So there are 2 aspects of this: commerciality, was it used for a commercial purpose, and kind of what the purpose itself is, whether it's different or not, which we often call transformativeness. And here it was a commercial use, and the purpose wasn't so transformative. Yes, there might be some slightly different pieces of information that are coming out from the system, but it is a legal research tool, just like Westlaw was and Westlaw headnotes were. So factor 1 goes to Thomson Reuters. Factor 2 is the nature, so basically like how expressive is the stuff that's being copied. Here, headnotes are copyrightable, but they're not that expressive. They're very, very factual. So this goes to Ross, but the second factor is always the weakest factor, and it's very rare that anyone will care about the second factor in coming to the ultimate conclusion. Factor 3, how much of the work was taken. This again will go to Ross because the output doesn't necessarily contain the Westlaw headnote itself. So the user isn't going to see what's going on. It's more intermediate copying in the middle. And then factor 4, which either factor 1 or factor 4 are the most important, depending on the court you're listening to. Factor 4 is market effect. So how much does this particular copying use affect the market of the original? And this could both be actual markets and prospective markets. So there are 2 markets that Judge Bibas is playing with. One is the existing market for legal research tools. That seems pretty clear that they've created a competitive product that's going to compete. But interestingly, Judge Bibas also talks about this prospective market in having data that could be used to train AI systems. And that even though Westlaw is not doing this yet, in fact, Westlaw has its own proprietary system, it could do this, and that's enough. So these 2 markets and market effects, in combination with not really having a transformative purpose, means that fair use does not apply here, and Thomson Reuters seems to succeed, at least for the 2,243 headnotes that were being addressed in the summary judgment decision. There are still thousands more headnotes that are going to be addressed in full at trial. Good luck to the jury that has to listen to each of these headnotes. Supposedly Judge Bibas reviewed all 2,243, or at least his clerks reviewed those 2,243. But it is interesting this is the first fair use AI decision that we have. So what can we really learn from this? Because the system that Ross was using was not generative AI, which is a key difference here. It's still like a search and retrieval system like Google or any other search system. So we're not necessarily getting the competitive aspect in the same way. There might be a potential market impact, but it's not going to be as clear as it was in this case. The more worrying aspect of the market effect would be this developing a market for AI training data. And that might be particularly persuasive in some of these cases involving large, I'll call them data compilers, but effectively companies that have a lot of copyrighted stuff. So New York Times, for example, or Getty Images, which have large troves of data that they could use or license to have other companies train on them. Individual authors, yes, Game of Thrones might be a good book. It's also not going to be that important for training an AI system because it's such a small piece of the billions of pieces of data that need to be included in a training system to actually make it efficient and effective. So because of all of that, it could really vary depending on the judge and the plaintiff. On the purpose for factor one, I think that will be a bit different because the purpose is creating a generative system, and any of the intermediate copying that's happening is all to create this new purpose, which is very different. So potentially stronger there. And if you have factor one and potentially factors two and three in favor of the AI system, factor four might not be enough by itself. But judges will weigh these differently and will kind of give different amounts to each. So we will have to see what happens in that space. But that's the big update. There have been a few smaller updates involving copyrightability. So there was a big report released by the Copyright Office 3 weeks ago now, which basically said the same as what the Copyright Office have been saying for years now, of if it's not human created, you're not getting a copyright. And so, at least according to the report, it's very clear now that a prompt alone will not get you a copyright in an AI generated thing. That said, there were interestingly two pieces that were supposedly the first ever AI generated works to receive copyrights earlier this week. That's misleading on multiple levels. I highly doubt they were the first things to have used AI to get copyrights. In fact, the Register of Copyrights at a conference I was at last year said they had registered many things that were AI generated. The problem is when the Copyright Office denies something, and if it gets appealed, that will generate a report and we'll actually understand their reasoning and why it was reported. We don't get that if there's just a registration. There are hundreds of registrations that happen every day. We're not going to have fanfare over each one unless the person who's registering it or their attorney happens to go to the press and tell them about this. So there was a work called A Single Piece of American Cheese that was registered earlier this week. And this was AI generated, but it was registered as a compilation. So none of the individual components that were AI generated were registerable. But you could use this tool called inpainting and basically go and select certain portions and change it in certain ways. And basically put many prompts for, I want to change this aspect to make it more circular, this aspect to make it purple, whatever it might be. The issue with that is you still aren't getting a copyright on the exact things you're changing. You're just getting a very thin copyright on the entire compilation of how things coordinate to each other and how they and that things have been changed in certain ways, but not over the changes themselves, which is very confusing. So if someone is going to try to copy this piece, a single piece of American cheese, likely the copyright owner could sue and probably would win if it was an exact match. So there still might be effective copyright registration, even though in practice it's very thin only under certain aspects. What will probably really matter is how much was done initially with that prompt and how much was modified. If you modify quite a bit, then those slight changes might at least make a broader compilation, which could be effective to copy or to prevent copying. But if it's just kind of making a new character and then you're changing certain aspects about the character, that base is still going to be under copyright. So like to take another example of Steamboat Willie, who is now in the public domain, but Mickey Mouse and the later versions of Mickey Mouse are not. So it'd be like taking Steamboat Willie out and then everything that's been added to become Mickey Mouse, like rounding the ears a little bit more to make them more mouse-like and less rat-like, shortening the tail, like certain things like that. But you're not even getting it over those elements. You're just getting it over kind of aspects and correlations of those elements. So more will probably be seen in this space, but for those of you who do anything copyright, you'll likely be hearing about it in the coming weeks.
Well, we're glad to have you on board, Michael. Got to have a resident copyright expert keeping us up to date on all this
For
madness.
for better or for worse, it is the main policy lever for whether AI will be lawful or not. So, and thank you, Rebecca, for putting the link for the decision. Here's the one article on single slice piece of American cheese.
Nice. I love the title, but it is making me slightly hungry. So with that, let's just open it up. Any questions? Anything top of mind for other folks? A news already inspired me to change my buying habits, so that's good. I hate shipping fees too. I didn't realize that, and now I feel like I've been scammed for the past however many months, so that's not great.
Yeah, I bought a magazine online earlier this week. The magazine itself was, I think, £7. Shipping was $24. So
No,
I was with the shavings and shipping, I actually bought a t-shirt in addition to it. So I'm quite happy.
that's I see. I see the logic now. This is why. This is a brilliant move. This is as my wife calls it, girl math, right?
Yeah.
Yeah, she throws one thing away, and that means she gets to buy like 15 more. I don't know how it works out. It's beyond my minimal math skills. Uh, any other AI comments or buying tips? I could, if we can save $1.
I guess I have a general question for you guys. It's not very relevant to copyright and that. But so I'm in a class right now on like race and technology and how they interact. And I'm learning a lot about AI and like just algorithm usage and things like sentencing and like in the criminal justice system. Which like I understand there's increasing a lot of this being done, and the regulations aren't really existent or aren't really enforced. So I'm curious if you guys have any thoughts in general about the future of AI use in the justice system as opposed to the private sector.
I will just do a plug for ProPublica because they did great reporting on this back when, like, way before AI was really, like, obviously AI was a thing. It was not a publicly known thing that AI was actually doing valuable things in our criminal justice system. Well, maybe not valuable, but they are doing substantive things in the criminal justice system. Um, and which I think really highlights the importance of not just lawyers in the system, but also investigative journalism, of figuring out how these systems are being used. Uh, Also really interesting to see how some jurisdictions have been very public about using tools for a variety of things. So sentencing, um, predictive policing as well on the front end, and trying to kind of real. Some of them have been better about it, about thinking about how do we actually make this a better thing so we can prevent people who might be at risk of recidivism, or help them, get a job, connect with family, what have you, versus just let's put more police in this area and that will solve things because that's a reasonable thing to do. Um, and similarly with the kind of using AI in sentencing, I believe some courts have started to include rules of having to release how they're actually using those tools in their calculuses, which I think is really good. And I think is something that we should try to think about, not just in criminal justice, but the law more broadly of if we are using these tools, it might make sense to reveal some information about that, just for transparency's sake. Because it is really tough if you're just getting a number out of a box and okay, why am I being sentenced with that? It makes really no sense.
Yeah, no, there's
Is
really cool
he?
scholarship out there from like courts and in which they use AI to look at like mugshots, and they're able to determine
Yeah.
how like the quality of like your facial grooming and how chubby your face is, for example, has like very significant chances of what your flight risk is determined to be and things like that, which
Yeah.
like judges are more susceptible to than you think, unfortunately.
And to even bring back to generative AI, police departments have used generative AI in making lineups and data and the arrays of various images. They'll be like, "Oh, we heard that the suspect was like 6'4", this race, wearing this color shirt. Let's just have generative AI figure out what that might look like."
Yeah.
Um, yeah, not necessarily the best approach either.
Yeah, I've seen recently a few police departments saying that they're using generative AI to make police reports. So like
Yeah.
the body cams are really prevalent now, and so they could just make a police report right from body cam footage.
Well,
But
and
Christy,
one
did you
thing,
want to
oh,
jump
oh
in?
no, oh, go ahead. No, no, I didn't want to
No,
cut you
no,
off,
I was, I
Rebecca.
was,
Sorry.
I was coming to you, Christy.
Yeah. Oh no, I was just going to say, just well, you can't. I took the cover off, but I put in the AI snake oil. I don't know if anyone has read that from a couple authors' names are escaping me, but researchers from Princeton, formerly at Google. But this book, which talks about some of the inherent problems with predictive AI, right? Using AI to predict things like who will be successful in a job, predicting recidivism, those sorts of things. It really highlighted to me why it is important, and I don't have a technical background of really thinking about the differences in AI, and that predictive AI is very different than generative AI. And it's, generative AI can be used in, in ways like compiling police reports, but some of these systems that and I have not finished this book yet, but certainly the thesis is that predictive AI has its own brand of problems. It's trying to predict the future, right? And that's very different. And regulations need to be targeted in a different way than saying that should be applied to all AI generally, because it's very different than generative AI. So and they overlap, but that's something that really struck me in thinking about, when we think about, was it extractive or generative AI or predictive, and how they differ.
I think it's worth also really paying attention to the question of compared to what in a lot of these contexts. So I may be a bit of a contrarian on some of these issues, because I think we've all probably seen that diagram of the sentencing length compared to when a judge last had food. And so would I rather have, and acknowledging I'm a white male, right? Acknowledging though, if there were a judge who just was waiting for their lunch, would I rather have that judge or an AI predictive system? Maybe the AI system, right? So doing that compared to what analysis, I think, is really important. I think about this mainly in AV context. So autonomous vehicles relying on AI, they're getting increasingly sophisticated. If there's one accident involving an AV, people are like, oh my gosh, these things are gonna just murder everyone. And I think, have you driven on the streets of Miami? I would trade anything to drive with a bunch of AVs that have a 1 in 1,000 or 1 in 100,000 chance of hitting me versus a 1 in 10 right now. So the compared to what, I think, is really fun to think about. But that's another rich area for notes. Not sure if anyone was hungry for one. Well, I know we're getting close to the top of the hour. One thing I wanted to stress to all you brave individuals for spending an afternoon with us is, please spread the word. If you enjoyed this at all, please tell your classmates. If you didn't enjoy this at all, please tell me. And that would be great to know what you would have liked more of, what you would have liked less of. We're planning on doing this again on February 24th at 12 p.m. Eastern. So you can join us for an actual lunch GPT, or for the West Coasters, a coffee GPT, or we'll come up, branding to be determined. I guess I can't use generative AI to come up with that if I want to try to protect whatever's happening. But thank you to everyone. I guess we can see if there's any final last seconds comments, but otherwise, I hope everyone has a nice long weekend ahead. If you've got a partner, get them a cookie, get them a heart or something. Enjoy your Valentine's Day. And nice seeing you all. And thanks again for joining us.